We're going to be answering one of the biggest questions that we get from many of our clients. Can you get the evidence against me thrown out in court? As a criminal defense attorney in Phoenix, Arizona, this video will be very helpful for you if you want a big but yet in-depth understanding of what all the violations might be that might help you get your charges dismissed by throwing out the evidence in your case. Very important. You should not be using this advice to represent yourself. You should always be hiring a criminal defense attorney, preferably us, if you're facing charges. There might even be attorneys watching this video to get a basic understanding of what can be happening with Arizona laws. So please, if you find this video instructional, helpful, please like, share, subscribe, all of that fun stuff, because this is very important. We're going to go through this PDF that I've created, and if you want a copy of this, you can download it yourself too. So can you get the evidence against me thrown out of court? One of the biggest questions once a criminal case actually starts, because it's what a lot of people are worried about. So let's begin here. If law enforcement violated your constitutional rights in obtaining the evidence that the prosecutor now wants to use against you, your attorney can file a motion to suppress that evidence and keep it out of court. This information sheet answers the common questions about motions to suppress and explains how this powerful defense tool can be used to your advantage. So first off, what is a motion to suppress? A motion is a formal, most of the time it's written, request that's filed with the court. If it's not written, it might be an oral request, but that's rare for a motion to suppress. A motion to suppress is a request that the court actually toss out, get rid of, or suppress that specific evidence in your case. What are the types of evidence that can be suppressed? So evidence that was unlawfully obtained in violation of your constitutional rights is subject to suppression. And this includes tangible physical evidence, commonly weapons, drugs, drug paraphernalia, clothing, computers, cell phones, anything that's physical evidence. Testimonial evidence. This is statements you made to the police, including these confessions or statements that might have been overheard by the police. Out-of-court identification by means of a photo lineup, mugshot lineup, or a standard lineup outside without photos, or a show-up, which is a very specific eyewitness interview type style drive-by. Other thing that can get suppressed here is evidence that was derived from unlawfully obtained evidence. Very complicated. We're not going to dive into everything with this, or else this video would literally be hours long. But there's a general overview of the types of evidence that can be suppressed. Commonly, these are the legal grounds for a motion to suppress. The United States Constitution establishes your fundamental rights in relation to the criminal justice system here in Arizona. These rights include the right to be free from unreasonable search and seizures, the protection against self-incrimination so that you cannot be forced to be a witness against yourself, the right to have an attorney assist in your defense, and the right of due process of law and equal protection under the law. If these rights are violated, you have the grounds for a motion to suppress. What types of situations might support a motion to suppress? Common situations that might support a motion to suppress include these examples. An unlawful search and seizure, which may occur if the officers had no warrant in a situation where a warrant was required, or the officers had a warrant, but it was defective or flawed, or the officers had a proper warrant, but they improperly executed it, or the officers were not legally on the premise where the evidence was seized, or the search exceeded the specific area that the warrant specified. The search went beyond the items that were specified in the warrant. This is very important. These reasons for the unlawful search and seizure, you should help your attorney bring these to light. But once again, you should not be doing these yourself. The next reasons we get into here is an unlawful out-of-court identification, which may occur if the process used to identify you as a suspect or a perpetrator, i.e., having the witness review mugshots or a photo lineup or a lineup at a police station, was unfairly prejudiced against you. Very advanced work here. Another reason to have the suppression motion filed is a break in the chain of custody, which is detailed procedures that are in place to safeguard evidence and ensure that it is not tampered with from the moment it is seized until the moment it is brought to court. If these procedures, referred to as the chain of custody rules, are not strictly followed, then your rights of due process may have been violated and your attorney may have grounds for a motion to suppress that evidence. Another reason for a motion to suppress could be an unlawful interrogation, where you may have been subjected to an unlawful interrogation if you were not advised of your rights. The officers continued to question you after you asked for an attorney. This is important. An attorney does not need to show up as long as you ask for it. You are good, but you must then also stop talking. The conditions of the interrogation rendered your statements unreliable. You were subject to physical force or threats during the interrogation. Now, when a motion to suppress is usually brought up, is this. A motion to suppress is usually brought up before trial. And keep this in mind, is it's usually kind of right before trial. And that's a strategy based on the way defense attorneys and prosecutors work to resolve cases and try and get them dismissed. But once your attorney has had an opportunity to review the police report and other evidence, to interview you and conduct our independent investigation, that's when we are able to draft, file, and argue a motion to suppress. So we file the motion to suppress. What happens next? The judge will either rule on the motion immediately, based on the sworn statements and other evidence filed within the motion, or set a date for the hearing for oral argument. So what happens at this hearing? So at the hearing, the judge will hear testimony from witnesses and legal arguments from the attorney. Once again, testimony from the witnesses is basically the first half, and argument about the law from the lawyers is the second half. The prosecutor will call in the police officer to testify about what happened during their encounter with you. Your defense attorney will then have the opportunity to cross-examine these police officers. The goal of the cross-examination is to show that the officer's testimony is unbelievable or unreliable because of bias, a motive to lie, an inability to observe what they claim to have observed, or impaired perception. Your attorney can also undermine an officer's credibility by showing that his testimony at the hearing is inconsistent with what he previously wrote in his police report. In addition to law enforcement officers, other witnesses may be called to testify as to what happened during the police encounter, i.e. this includes people who were present when the officers entered the home or passengers in a vehicle when you were pulled over. Next, and one of the most important parts, is what happens if I win the motion to suppress. If the judge rules in your favor, then the evidence at issue in the motion will be banned from court, i.e. suppressed. This means that the prosecution can't use it against you in court to try and prove its case against you. However, the prosecution is still allowed to try and use other evidence to prove their case against you. If, however, the evidence that was suppressed is so crucial to the prosecution's case that there's now insufficient evidence left to prove the charges against you, then the judge themselves might decide to dismiss one or more or even the entire case against you. Additionally, the prosecutor at that point might also dismiss the case on their own if they don't have enough evidence. So at the very least, winning a suppression motion may result in a better plea offer if the prosecutor still is unwilling to dismiss the case. What happens next if you lose the motion to suppress? If you do not win the motion to suppress, then the case continues moving forward towards trial. Even if you lose the motion, this process can be valuable to the final outcome of your case. After all, a motion to suppress gives your criminal defense attorney an opportunity to learn about the prosecutor's case against you, to observe the prosecutor's style and demeanor at court, and to see how the officers that were involved react to cross-examination. All of this will be great assistance to you at your trial. Now, what can you do to help your lawyer win the motion to suppress? Tell the truth, the whole truth. Motions to suppress are won or lost based on specific facts. So your lawyer needs a detailed and accurate account of exactly what happened in your encounter with the police. Remember that your conversations with your lawyer are protected by attorney-client privilege, so the substance of those conversations are confidential. Be scrupulously honest and tell your lawyer the whole story, from beginning to end. Details that may seem unimportant to you may be highly relevant to your lawyer. Thank you very much for going through these reasons and learning more about if you can get the evidence against you thrown out in your case. Once again, this video was not meant to be a you do it yourself. This video was meant to give you a better idea of the different things that we as an attorney review and examine in your case, and what we do sometimes in order to try and get better plea deals, or in order to dismiss your charges, or in order to dismiss the entire case against you. Please understand there may be reasons why we, your attorney, or any of your other attorneys may not want to do a motion to suppress. And there are strategies behind that because sometimes plea deals get thrown out if we do that. Not always, but that's usually the reason why it's a bad idea to file this motion, especially if we know there's no chance at winning. Please understand, if you're an attorney watching this video, that there are a ton more videos that we've created that go deeper into each of the aspects of this video. So please don't take this video as the end-all be-all. And now, most importantly, if you are facing criminal charges, please make the right decision to contact us now early. We care about your future and we want you to have the best outcome possible. Once again, my name is Zachary Divelbiss. I'm the owner of Future First Criminal Law. Please contact us if you want a free consultation, and I look forward to helping you out.